Nixon v. United States, 1993. Not the president, a federal judge named Walter Nixon. He was convicted of perjury. He went to prison, but kept his judicial salary because he hadn't been impeached yet. Eventually, the House impeached him, and the Senate removed him using a procedure where a committee heard evidence and reported to the full Senate for a vote. Nixon sued, arguing this was not a real trial as required by the Constitution. Article 1 says the Senate has the sole power to try all impeachments. He claimed the Senate must conduct a full trial before the entire body, not delegate fact-finding to a committee. The Supreme Court said, political question. The word sole means the Senate has exclusive, unreviewable power to decide impeachment procedures. Courts cannot review how the Senate conducts those trials. Chief Justice Rehnquist argued that defining try would require courts to make policy judgments about appropriate Senate procedures. That's committed to the Senate, not to the courts. But this reasoning is absurd. Courts define constitutional terms all the time. What's a trial under the Sixth Amendment right to a jury trial? Courts have detailed standards. What's due process? Courts define it. What's an unreasonable search? Courts tell us. But what's a trial in impeachment? Too political. They won't say. Justice White dissented. He said the Constitution sets minimum requirements. Try means something. It requires hearing evidence and making findings. The Senate can't flip coins or decide without any process. If courts would review a coin flip trial, they should review Nixon's claim too. The majority worried about judicial review destabilizing impeachment. An official gets impeached and removed, then sues. A year later, a court might reinstate them. But that's true of any constitutional violation. Courts remedy violations even when it's inconvenient. And then the court would have to say, we'll review extreme violations, but defer to reasonable Senate judgments. Instead, they said, no review at all. Here's what Nixon means. Impeachment is whatever Congress says it is. The case involved procedure, how the Senate conducts trials, but the logic extends to substance. If courts can't review procedures because the Senate has sole power to try, they can't review impeachment grounds either because the House has sole power of impeachment. What counts as high crimes and misdemeanors? Whatever the House says. The Senate can remove for any reason or no reason. No judicial check. Trump's 2 impeachments showed this. People debated whether Ukraine dealings or January 6th were impeachable offenses. Legally, it doesn't matter. If the House impeaches and the Senate convicts, it's done. No court will review whether the conduct actually constituted high crimes or misdemeanors. What if Congress impeached the president for being left-handed? Under Nixon, that's unreviewable. The political remedy is voting out representatives who abuse impeachment, but there's no legal remedy. The case also means Congress can violate its own rules. The Senate has impeachment rules requiring certain procedures, but if the Senate ignores those rules, courts won't enforce them. Senate rules are just suggestions. The founders debated impeachment grounds carefully. They rejected maladministration as too vague. They wanted impeachment limited to serious misconduct. But Nixon lets Congress impeach for anything. The constitutional limits means nothing if courts won't enforce them. Impeachment is supposed to be the ultimate accountability mechanism for executive and judicial abuse. But with no judicial review, it's purely political. No legal standards, no enforcement, no review. Congress has absolute power, and courts have declared themselves powerless to check it.